Buffalo, New York. As I mentioned, he had previously spoken at this conference a couple years ago. He's played a huge part in environmental law and mass tort cases throughout New York and actually nationwide, many of which have been very high-profile cases. Richard, I guess if you wanted to say some few words, or otherwise, I'll let you start.
That's good. Thank you. Well, we're going to deal with the State Environmental Quality Review Act today, which is probably the most important environmental law in New York State. But prior to that, you should know that it's only one of the laws that deals with impacts on environmental impacts on projects. And I assume that probably everyone in the room is here because they have projects that they wish to stop because they're environmentally impacting. But you should know that there are a lot of other laws on the state, federal, and local level. For example, on the federal level, there's the Section 4F of the Department of Transportation Act, the National Historic Policy Act, the National Environmental Protection Act. On the state level, there are laws, both the state and federal level, dealing with the wetlands and other important landforms. There's the Public Buildings Law, the Historic Preservation Law, coastal zone laws, and on the local level, there are various zoning laws, including the requirements of a zoning board of appeals when a variance is asked for, site plan approval, and if parkland is involved, the public trust law. And those are just a few, which is, here's the commercial, why you should have to hire a lawyer if you want to fight a project. But SEQRA is perhaps the most important. But you should know that even if you're successful on a SEQRA claim, showing that a state or local agency has not properly complied with these SEQRA regulations, that doesn't stop the project for all times. It will void any approval that's given, but if the applicant is tenacious enough, they can come back and ask that SEQRA be properly complied with, and ultimately, if it's properly complied with, SEQRA will not give you any relief. So in fact, there are very few laws, very few environmental laws that will totally stop a project. The Endangered Species Act, for example, is one of them. The Department of Transportation Act is potentially another. But very few of these laws will stop a project. What they will do is void the approval, require a lot of delay for the applicant, require a lot of cost for the applicant, and potentially you'll win your project through attrition. Now, the SEQRA, the State Environmental Quality Review Act, that is called either SEQRA or SEQRA, was patterned after the federal law that was passed in 1970, the National Environmental Policy Act. And I'm a lot older than most of you in the room. It's incredible to me that it took the government till 1970 to require federal agencies to consider environmental issues when they're dealing with projects. Now, SEQRA has two major changes from NEPA. NEPA shines a light on the project, but does not require an agency to make any particular decision. And it only requires an environmental impact statement where there is in fact a major federal project that would significantly affect the environment. SEQRA, however, the legislature, knowing what NEPA required, made SEQRA a lot stronger. First of all, it doesn't just apply when there will be a significant adverse environmental effect. It applies when there may be at least one significant adverse environmental effect. So the bar of requiring an environmental impact statement under SEQRA is much lower than it is under NEPA. The second major change in SEQRA is that while NEPA requires no particular decision from the agency, no matter how bad the project is environmentally, they can still approve it. SEQRA actually has substantive, not just procedural requirements. So it requires the agency that's dealing with the project to not only consider the environmental effects, but to choose those alternatives that are least environmentally impacting. And if an environmental impact cannot be avoided, they must show that they've provided mitigation to the greatest extent practicable of any non-avoidable environmental effects. So, as opposed to NEPA, SEQRA applies when there may be an effect, a significant effect, and it requires substantive decision-making. Now, as to the procedures of following SEQRA, which are contained in the regulations that I've indicated in the SEQRA checklist, and by the way, those regulations were amended in January. There were not significant change. There were not a lot of changes, but there were some significant changes, particularly in the area of those kinds of projects that are exempted from environmental review, called Type 2 projects. And there are a couple of other changes. But if your project was approved prior to January of 2019, you still would use the old regulations, but the numbering is much different. If you're successful on a SEQRA case, what you will accomplish is to void the approval of the project, and you will receive injunctive relief to stop the applicant from going forward with the project or the state agency until they've properly complied with SEQRA. When you file a lawsuit applying SEQRA and trying to stop a project, you often need some kind of relief because the project may be going forward. There may be construction happening, there may be forests being denuded, there can be all sorts of adverse environmental effects that may happen before you have a chance to actually get into court and have the court hear your claims. In that instance, you have the right to request either a temporary restraining order or a preliminary injunction. Now, a temporary restraining order only lasts, or is only supposed to last, until you can get into court. It's a short-term kind of thing. A preliminary injunction, however, lasts until the court makes its decision, and if the decision is favorable to you, the court will issue a permanent injunction until all the laws that have been violated have been fulfilled. However, in order to get a preliminary injunction or a temporary restraining order, you have to show three things. First, that there is potentially an immediate and irreparable injury that will occur without getting injunctive relief. Secondly, that you can show to the court that there's a probable success on the merits of your case. And third, that the equities tip in your favor. Usually in an environmental case, it's not too difficult to show irreparable and imminent injury. The difficulty comes about showing probable success on the merits before you've even argued your case. So you kind of have to do it, almost have to do it twice. Once at the preliminary injunctive stage, and once when you actually argue your case. The other thing you should know about SEQRA is that there are very short statutes of limitations. If you're dealing with a state agency approval or a city approval of a project, a city agency, there's a 4-month statute of limitations. However, if you're dealing with a town or a village approval, let's say site plan approval or a variance granted by a zoning board of appeals, there's only a 30-day statute of limitations. And generally speaking, the community often believes that, you know, we're the government and we're here to help you and that they'll make the right decision. So they don't really organize until the agency makes the wrong decision. And they have to organize, hire a lawyer, raise funds, and do all that within 30 days if it's a state, if it's a town or village, or 4 months if it's a state or city decision. So it's not a lot of time, and that is one of the problems with SEQRA. The other problem with SEQRA is what lawyers call standing. In order to actually bring your lawsuit, you have to fall within the zone of interest that the law is trying to accomplish. And also, you have to show that you've been injured in a manner different than the public at large. Now, that was very problematic, the second step of that test, until a case that Rachel and I handled in the Court of Appeals in 2015, where the court finally said that the injury different than the public at large does not require that your injury be unique, and it does not mean, and standing is not lost because more than one person has been injured in the same way. So multiple people being injured won't stop you from suing, which is really should have been obvious, because with the old rule, the more people that were injured, the less likely that anyone could ever sue for the injury. So that you still have, it's still a difficult issue, but at least the Court of Appeals has issued rulings that make it a little easier. Now let's talk a little bit about SEQRA itself and the regulations. First of all, what does it attempt to accomplish? Well, first of all, like NEPA, it shines a light on the project and its potential adverse environmental effects. It does not allow an agency to make its decision merely on social and economic reasons, merely for social and economic reasons. It requires the agency to balance social and economic reasons when they're making a decision to approve or not, to balance those decisions with adverse environmental effects. And as I said before, they have to certify that they've avoided all significant adverse effects that they found, and further, that they've avoided and then mitigated those that cannot be avoided. That's another Court of Appeals, while determining that the requirements, the procedural requirements of how you go about applying NEPA, SEQRA, must be literally construed and strictly construed on the issue of balancing in the final decision making. There is a quote rule of reason that applies, which gives the agency a tremendous amount of wiggle room in terms of making their final decision. And your easiest case is one where they decide not to do an environmental impact statement, because then all you have to show is there is at least one potential adverse environmental effect. The hardest case is when they do an environmental impact statement and you are arguing that it was done inadequately. And in deciding both whether to do an environmental impact statement and after an environmental impact statement is done, a test is applied called the hard look test, where the agency has to identify the areas of environmental concern, take a hard look at them, and then give a reasoned elaboration for their decision. So if they decide not to do an environmental impact statement, they can't just say, there's no adverse environmental effects, and therefore we don't have to do an environmental impact statement. They have to show that they've identified the areas of environmental effects and how they've taken a hard look at them and why those environmental effects, either they don't exist or they're not significant. Okay, the first step in the SEQRA process is designating a lead agency. Now, the lead agency is important. The lead agency is the agency that is responsible for SEQRA compliance. And it's important because you will often have a good sense beforehand of where a particular agency is thinking about the project. Particularly on the local level, you have a good sense whether your town board or your planning board or your zoning board of appeals is developmentally oriented, which most of them are, by the way. And the entities that can be lead agencies are what are called involved agencies, or agencies that have some authority over the approval of the project. It might be a wetlands permit, it might be a speedies permit or a water discharge permit. It might be a zoning change. Anywhere where an agency has some kind of approval authority, they are an involved agency, and they could ask for lead agency status, and you want the agency that asks for it to be the agency that at least will give you an even-handed approach to SEQRA. And if there are disputes over lead agency status, then the commissioner of the DEC decides which agency should be the lead agency. The stuff I'm going to talk about now is really more relevant to law students than it probably is to all of you, because we're really, to some extent, getting into the weeds of SEQRA, which is difficult for non-lawyers to really deal with. And many judges have never dealt with SEQRA before, and you have to educate them. Okay, the next thing, once a lead agency is established, I don't know if I'm following your things right.
No, I think we should talk about our case.
Yeah.
Our time's almost up.
Okay, well, the next thing is what's called determination of significance. The lead agency has to determine whether or not the project involved is what's called a Type 1 project. And Type 1 projects are those projects that are more likely than not to require an environmental impact statement. They, in fact, create a presumption that an environmental impact statement needs to be done, but but just because a project is a Type 1 project doesn't require that an environmental impact statement needs to be done. The applicant or the agency can rebut that presumption. The other two kinds of types of actions are what are called Type 2 actions. These are Roman numerals, Type 1, Type 2. And those are actions that are listed in the regulations as exempt, so that there is no, once an action is determined to be Type 2 under the regulations, there is no further action under SEQRA that's necessary by the lead agency. But Type 2 actions are supposed to be those actions that have already been determined generically not to require an environmental impact statement because of their nature. Painting yellow lines on a highway, maintaining a building, maintaining parkland, things of that sort. However, the Type 2 exemptions simply don't apply if the action is otherwise a Type 1 action under the regulations. And there are two sections of the new regulations. They were in the old regulations too, but under different numbers, and I've given you the new numbers. that deal with when an action is a type 1 action. For example, if in a non-residential project, more than 10 acres of land is going to be used in the project, that automatically becomes a type 1 project. If more than 2 million gallons of water will be taken per day, that's automatically a type 1 project. If it's a type 1 project, the type 2 list of exemptions don't apply, and therefore that project cannot be considered exempt. And agencies often try to say they're exempt so we don't have to go through the SEQRA process. And in fact, in the Ravenswood case that Rachel Treichel just talked about, initially the DEC said it was an exempt project because one of the exemptions is when there's a ministerial action that requires no discretion on the part of the agency. That's considered type 2. Of course, in the Ravenswood case that Rachel talked about, since the DEC had the discretion to require various things, they had discretion, and therefore the court determined that the exemption did not apply. And then everything that is in type 2 or type 1 is called an unlisted action. It falls in between. And there is no presumption applied to unlisted actions. And there are different filing requirements. Now, as indicated in the SEQRA checklist, type 1 actions can be, for example, if there is significant impacts to the environment dealing with removal of or destruction of large quantities of vegetation, encouraging or attracting a large number of people to the site after the project is done than would otherwise be there, a significant increase in traffic or traffic problems, impairment of the quality of architectural or archaeological sites, potential pollution cause, water pollution cause to surface water or groundwater resources, any fish or birds impact or any of their habitat disturbed, any endangered or threatened flora or fauna, any material conflicts with the community's current plans or goals. So if they have a comprehensive planning document, it has to be consistent with that document. And I won't go through all of them, but the rest of them as well. So the agency, in identifying the adverse environmental effects, should go through this checklist and see if any of those effects, one, are there, and two, if those effects are significant. And if they are, they will be required, even if one of them is there, they're going to be required to do an environmental impact statement. And they have to file what's called a positive declaration indicating why they have to do an environmental impact statement. If they find that there's not even one significant adverse environmental effect, then they issue what's called a negative declaration and give the reasoned elaboration concerning what they've looked at and why there are no significant adverse environmental effects. Now, if an environmental impact statement has to be done, what must be in it? Well, again, the same issues, all the issues that they found to be significant has to be in the environmental impact statement, plus some other things. And the most important part is a review of alternatives to the proposed project. The agency in an environmental impact statement must review not all alternatives, but a reasonable array of alternatives, and look at the environmental effects of each of those alternatives to determine which one to choose. And then they hold a public hearing after a draft environmental impact statement is done, which also allows for written comments as well as comments at the public hearing, EIS, the final environmental impact statement. And particularly the state agencies will often accept those comments. The whole SEQRA process ends in what's called a finding statement. In the finding statement, the lead agency says, we're going to approve this project or not, or what alternative they're going to choose. And they say why, and they certify again that they've avoided all adverse environmental effects or mitigated them. Now there's a couple other ways that environmental effects can be avoided. If it's an unlisted action, they can do what's called a conditional negative declaration. A conditional negative declaration means that there's been a back and forth between the agency and the applicant, and they've made changes to the project that avoids environmental effects. A conditional negative declaration cannot be done for a type 1 action, but it can be done for an unlisted action. There's also another issue called segmentation. Oftentimes, agencies will break their project up into little segments because the smaller segment won't have the significant adverse environmental effects that the whole project will have. For example, in the early days of NEPA, a 30-day, let's say a 30-mile highway was broken up into 1-mile segments. The whole 30-mile highway is going to have significant adverse environmental effects. But this one segment, this 1-mile segment, may have no effects, might not cross a wetland or might not otherwise need cutting down of a forest or go through a residential community or whatever. That's called segmentation. If a project is dependent upon each other, the two segments of a project are dependent on each other, that's called segmentation, and it's frowned upon under SEQRA and by the courts. And often the courts will overturn a segmented project. So that's, my time is up, and I will stop here. And if there are questions later on, we can talk about them.